SourceFed, I'm Trisha Hirschberger.
I'm Joe Beretta.
The long-awaited court ruling on two cases that pit religious views versus healthcare, specifically concerning certain types of contraception, was made today in favor of the individual company's religious rights.
To catch you up on what's been going on, in case you haven't been following, the two cases are Burwell versus Hobby Lobby and Conestoga Wood versus Burwell. Both Hobby Lobby and Conestoga Wood objected to providing certain contraceptives to employees and made their claims under the 1993 Religious Freedom Restoration Act, which attempts to combat laws that prevent someone from freely exercising their own religion as part of their First Amendment rights.
Both companies would have been required to provide health insurance that covers birth control under Obama's Affordable Care Act, and while not objecting to all forms of contraceptives, these companies said being forced to provide emergency contraceptives violated their religious principles. The court ruled today on a 5-4 vote that companies can indeed seek an exemption from the healthcare law.
The Affordable Care Act does not apply to all businesses, though. Small employers can choose to not offer any health coverage, and religious employers are exempt anyways.
Those on the government side of this issue believe that women should have equal access to healthcare services, and that doctors should decide which form of birth control is right for a woman, not employers. They assert that giving women access to effective birth control would reduce unwanted pregnancies and abortions.
The two companies, along with over 40 others with similar claims throughout the nation, say that there are types of contraceptives that are similar to abortion and that they prevent embryos from implanting in the womb, and they do not want to be involved with these types of practices.
So the major question here is, do for-profit companies have religious rights? And today, the Supreme Court said that they can object when it comes to the issue of contraception, citing that there are other ways that women can obtain cost-free contraceptives through a system currently in place for those religious nonprofits that are already exempt that we mentioned earlier. The decision says that they could extend the same system to employees of these new exempt businesses as well.
Now, the worry with this ruling is that it's going to create a slippery slope where companies can pick and choose who and what they want to cover. It starts with insurance, but then it can go to hiring practices, and where does discrimination fall in this whole thing?
Now, I 100% get not wanting to be forced to spend your money on something that you believe is fundamentally wrong. I also wonder what types of problems may arise from employers who, for example, do not agree with vaccinations or LGBT rights. So we ask you, where is the line between religious freedom and necessary health care, in your opinion? Let us know in the comments section down below.
Like the video, subscribe to the channel, and click the annotation for more news. I'm Joe Beretta.
I'm Trisha Hirschberger. I just chopped that annotation. Like, that was how I...
Just like diced it up?
Yeah. Julienne annotation.